All right, we're having the doors open, getting ready to go here. Good afternoon and welcome to today's ATI education webinar facilitated by GovMates on the topic of how to use and protect your intellectual property while performing federal contracts. We're going to dive into all of the really good stuff. There's a lot of information here, so I will be taking notes. If you see my head down, I'm literally writing notes because I know there's a lot that I'm going to want to remember. I am your event host, Meg O'Hara. I'm the director of the director of engagement, and I'll be monitoring the Q&A and facilitating today's discussion. For those who might not know a lot about GovMates, we are a technology scouting platform that connects small and non-traditional businesses with system integrators and agencies who are seeking innovative solutions to their federal challenges. So we provide matchmaking, education like this, resources, and more for ATI and our ecosystem. To get us started, I'm actually going to provide you with a few participation reminders if this is the very first time that you are joining us or if it has been a while. So first thing is first, if you'll just go ahead and click over to that next slide for me. You remove those distractions. We're going to keep this to about an hour. So if you can silence your cell phones, close down those open tabs, use this as a time to not get into your email, a nice little forced break, even, have a little bit of your lunch as you are joining us here today. We also encourage you to be active in the chat. You should be able to message everyone in the chat. So if you want to say hi, let me know that you can hear us. That would be great. In the drop down above, you might be able to see host and panelists or everyone. You can choose everyone, and that should be allowing you to jump in there. I actually turned it on today because for those of you using Zoom, sometimes it defaults to nobody can talk to anybody. We don't want that. And then we will also be taking audience questions as they arise during the discussion here. So if something is relevant to the group at large, we'll be sure to touch on it. If the question is a little bit more nuanced or will take, a significant amount of time to answer, we'll be sure to provide you with a way to connect post-event to get your questions answered. And those can be submitted in the Q&A portion. So we'll take a look at those. Finally, yes, there will be a recording. And once that is processed and posted, I will send it to the email address that was registered through the event today. And if you need a copy and didn't get one in your email, check your spam. And if not, you can reach out to ati@govmates.com. That email address will be at the end as well. And just let us know. We'll be sure to get that to you. So today and here is where I get to introduce today's panelist and great GovMates friend from PilieroMazza. This is Sai. And Sai, first, thank you for joining us today. And second, can you tell us a little bit about who you are and what it is that you do?
Sure. Yeah, I'm Sai Alba. I'm a partner at PilieroMazza law firm in DC. I'm actually the current chair of our government contracts practice. And so kind of our government contracts practice is pretty broad. We do a lot of different things from protests, claims, M&A activity with government contractors, the IP data rights issues, False Claim Act, protests, you name it, everything government contracts related. We have a pretty big group here, probably one of the largest GovCon-centric groups in DC and probably in the country. So that's who we are.
100%. And we'd like to have you guys on a lot. We actually just had Sarah and Nicole on back in July for a chat about employment issues that affect your bottom line, which is also one of our recordings. So we appreciate having your team back here again. And this for our agenda today, going to quickly run through that, and then I'm going to pop it back over to Sai. So for our agenda today, we're going to go chat through several topics related to IP, such as the difference between rights and ownership, the different types of IP, the rights government can hold and when they apply, when and how you can limit the rights in your IP, and some of the mistakes that federal contractors make when developing it. And like I said, there will also be time for questions at the end. I do not believe that credit is offered for this seminar, but I will keep an eye on that for future opportunities as well. That was a question that just came in through the chat box there. So, Sai, floor is yours. I have talked enough. I know we have a lot to get through here. So, like I said, Q&A goes in the Q&A box, chat goes in the bottom, and Sai, the floor is all yours.
Yeah, thank you, Meg. Yeah, and to the extent questions come up in between, I'm happy to answer things as we go. This beginning part, I was going to go through somewhat quickly because the types of IP people might already understand, but it's just sort of a background of where we're going. Starting with patents, and I'm not going to necessarily follow every slide exactly, so this is so you can take it and use it or look at the recording later. But patents, I'm not a patent lawyer. just so everyone knows, patent bar is a completely different bar that people sit for and take. Generally, people have higher level degrees, and in addition to a law degree, to be a patent lawyer. And when you're dealing with patents and filing patents, or is something patentable versus copyright versus trademark, we'll talk about that high level, but patent lawyers are best to that. So if you need that, I can certainly help you find the right person. But patents are very special and very different in the GovCon context because they have a whole separate set of rules with it. And you have to understand that patents are there to not necessarily give you anything more than what you already have. Same thing with copyright, same thing with trademark, actually. It's to exclude others from taking it from you. So that can be an important way to look at this, especially in the GovCon context, because we're going to talk a lot today about not what you have, but what you can prevent the government from taking from you, or what you can prevent others from taking from you. So that's just an important note. When you're dealing with patents, it tends to be either a thing or a process, some sort of actual invention or process, versus like a work of art or something like that, which is more copyrightable, versus like a trade name, which is more of a trademark. So there's differences and there's different rules on how those function in the federal marketplace. When you're talking about the government, what's interesting with the government is these clauses you see here and some of the DFARS clauses that are companions to it. There are very particular steps that you have to take in order to maintain ownership, which is very different from when you're talking about copyright or trademark, where generally you always maintain ownership vis-a-vis the government. It's just what rights they get. When you're talking about patents, if you don't follow the specific patent rules, you can actually transfer ownership and title to the government of that patentable item, unless you follow the specific rules, which you have to elect, might be in here actually. You have to like elect to retain title first. So you have to tell the government, hey, we created something that is potentially patentable and under this contract. And in addition to that, we want to actually maintain that ownership. So we're going to elect to take title. Once you do that, you then have to follow the steps in the FAR clause to actually go through and take title. So, and I think we're going to get into that as well later a little bit, but there's specific dates and timelines that you have to follow. So within the first period of time, you have to elect to take title. Once you elect, you have to file a provisional patent in the first period. Then after that, within a year, you have to actually file the actual patent. And all of that takes time and effort and money to do all of that. But if you don't follow all of those steps once you've said you were going to, or you fail to elect to begin with, the government can then take the patent and take actual ownership over that, not just get rights to use it, but actual ownership, which means you are excluded from using it unless you get a license back, which is something that can occur, especially if you're dealing with specialty contracts, like potentially under an OTA or under a Space Act agreement, if you're dealing with NASA, mostly NASA, or things like CRADAs, if you're dealing with, if you've ever dealt with CRADAs with the different DoD forces, or DOE too has things like that. If you have a situation where you're dealing with that special kind of contract, then you have to, if you don't elect title, you can still negotiate to say, fine, government, I don't want title in this patent. You can have title, but I still want a license to use it. And you can negotiate a license to use it for whatever period of time. It's sort of open to interpretation or negotiation on that point. The march-in rights thing I note here, just as so people are aware, it's very, very rarely used. It was talked about recently with the COVID vaccine and with also things around the pandemic about whether the government should just march in and take the patent from someone who otherwise has it. Because remember, when you file to get a patent or copyright or trademark, if you file to get it, that's the government saying, yep, I recognize you have it. But as part of that, like with all things in the government giveth and the government can taketh away, right? And so when that happens, if you have a patent and the government needs it for some critical reason, they can come in and say, hey, I know you have this, but I'm letting these other guys manufacture it and I'm just letting them do it. So you can sue me, but I'm marching in and taking it from you. And I'm letting them do it. That's just a fundamental part of patent law. So, especially the government space. So you should realize that that can happen. I don't think it's ever happened, at least not in recent history. So be aware of that as well. There was even some specific instance where the government was lobbied, where there was a very bad illness for children, where kids were dying, and the company that was doing the medicine for this was having trouble, and they weren't able to get things going and manufacture it here in the States. And they also had a facility in Europe. Europe actually used its march-in rights to get it wasn't vaccine, it was medicine for this rare childhood illness, and the US didn't. So we just be aware. So it doesn't really happen often, but it's just something to note.
Right. And in that case, it seems like it was a very specific example.
Yes, yeah. That's because that was the last one that I'm aware of where it was really talked about. Since then, it hasn't really come up.
Right. And the note that if you don't follow through on the specific like guidance as far as like following the directions, you could actually lose what you have already applied for or what you plan to retain is a big deal. It just like ignorance in the government is never bliss. And so it's a good time to make note of some of these things. So if you do go out for that sort, I know we'll get into it. If you do go out for that sort of thing, like set a calendar reminder, maybe.
For sure. And that goes to all the stuff we're going to talk about. There are specific dates for not just electing and filing patents, but also renewing, right? Or renewing trademarks, renewing copyrights. So yeah, I put that on your calendar, and it's different depending on what you're doing. So I don't know if we're going to give the exact dates, but just note that there are deadlines. And so you put that on your calendar and make sure that you're renewing it. I know when we do stuff for clients with like trademarks, for instance, we'll do that. It's 5 years or something. We'll calendar it out there. And then when it comes up, we'll calendar like 60 days, 90 days, whatever, 120 days, and put that all in there and ping folks if we're still working with them. If
you can remember to go to the dentist twice a year, you can remember to put this on your calendar.
Right. You don't want people to take it.
Right.
So if you have a situation where, like it says, where you're granting title to the government, so you have a patent, you're granting title. One of the reasons why they're not supposed to do that, or one of the examples, is if you're a small business. So if you're a small business, they're not supposed to attempt to take title from you. They're supposed to let you keep title the way it is. Now, if you're a large business, that particular exemption doesn't directly apply. However, if you are one of the main contractors that are doing things like counterintelligence or major, cryptography or breaking cryptography, those are some of the examples that I've seen recently where the government has not wanted independent companies to have title to that. Certain nuclear stuff that is not for civilian use, they don't want companies, for instance, to have a patent to nuclear bombs or fusion bomb, right? Like hydrogen bombs are basically fusion bombs. So that kind of stuff, they don't want private parties to have a patent to that and just sell it. Right. There are
We've seen Oppenheimer, yeah,
all kinds of other stuff. Yeah. But that's the kind of stuff. More realistically, though, if you're really into high-level cryptography, that's something they think could be problematic as well. So, and they might try to take it. When you're talking about copyrights, right? Original works of authorship, but you have to know too, it's things that are artistic. So much to my chagrin, if we come up with an amazing contract clause that we think is like perfect for a particular reason, that is not copyrightable. Now, there are certain things like webinars and things like that funny enough, that kind of stuff is copyrightable. But when you're dealing with certain things that you've created, it might not be, unless it's considered to be like a work of art. One that's come up recently in the past couple of weeks is I've had a few clients that amalgamate information that they get from other sources and don't necessarily transform it or materially change it, or things that are like customer databases and customer pricing information that maybe they've amalgamated over the years. It can be very valuable to them and to potentially other sources, but it's not necessarily copyrightable or directly protectable. If you're in a situation like that, check and see, one, if it is copyrightable, or two, if it's not, you have to just keep it close hold. You're gonna have to have NDAs. You're gonna have to have even internally, and make sure that doesn't get out. Protect it sort of with your life type of thing, like the the Coke formula or whatever. You got to make sure that's protected, because you can't automatically get copyright protection just because you created it, nor can you register and get a copyright for certain things like that. If you are dealing with something, if you're making something that is copyrightable, though, even if you don't register it, you still have a copyright in it. So when people create something, you've probably seen it on a bunch of webinars and things like that you've looked at, where it says little circle with a C, company name. That's because they probably haven't registered that with the Copyright Trademark Office. But what they have done is say, I did this, it's mine. And if you take it, you can still get sued. Same thing with if technically the government takes something outside of you doing it on a contract. You create it on a contract, we'll talk about that in a second. But even if the government takes something from you, it can be a problem. Further, the government under copyright law can't own copyrights. Different from patents, like we just talked about. If you don't elect, they can take the patent and they will own it. When it comes to copyrights, they're not supposed to own copyrights. Doesn't mean they don't do it. Or I've seen circumstances where there'll be contracts for software development. Well, it will say things like, you transfer, like, we own what you do. You'll notice that's not a FAR clause. They'll never cite a FAR clause for that proposition, because there is no such thing. There is no FAR clause that transfers title and copyrights to the government. You can transfer rights, but not title, not ownership. However, again, they still try to do it. And I've had fights before with the government where they're trying to transfer title. It's not appropriate. At the end of the day, though, people say it's my customer, I don't want to upset them. Fine. But just realize that is a major difference. When it comes to software, there is, in fact, the DFARS clause for software is interesting, because if it's commercial versus non-commercial, there are a bunch of different rules, which we'll also get into in a bit, about protecting your rights. But when it comes to copyrights in software, that can also include things like derivative works or other things like that. So you have to be aware that if you are using some software, you're creating software, that if you are taking someone else's software that's not open source, or depending on what the license says, read the license, and you are creating something from it, and you're doing that all by yourself, there can still be an issue as to that, because you're creating a derivative work from someone else's software, which has either common law copyright or actual copyright. That can also be infringement. Question here about, and this is what I was referring to, the Bayh-Dole Act, the effect on patent ownership when IP is derived from federally funded work, specifically subcontractor developed IP. So if you have something that, if you're a subcontractor and you are doing work for a prime, if you say, I want to elect to take title to this, and let's say you're a sub and you're a small business, and the prime is a large business. As I was alluding to, under the Bayh-Dole Act, they're not supposed to try to strip you of title, the prime or the government. They're not supposed to try to strip you of title. If you elect to take title, though, and you don't do it in time for the prime to follow all the steps it needs to do under the FAR, the DFARS, to elect to retain title, and then you don't go forward and follow all those steps, then that can cause you to lose title to the government if they want to try to take it. But they're never supposed to do that if you're a small business under the Bayh-Dole Act. So, and just be aware that if you are doing it, if you're going to elect title, you probably want to have some provision in your subcontract that allows you to directly elect through the prime to the government, so that you're not at the mercy of the prime contractor and what they are doing or not doing. That's what I would recommend for something like that. If you're talking about, there's another question, if you're talking about firm fixed price contracts where there's no deliverables or software in any way other than software being installed or delivered on hardware devices, technically the government, and we'll probably get into this too, but the government could have what they call inchoate rights, which I'll explain more later, where they're sort of ethereal, they're not actual rights. But technically the government could have rights in that software, but they don't actually have the code. And if they haven't asked for delivery of the code, then even though they might have rights in it, you could still charge for the code. So that's a way to potentially protect you, and you can charge whatever you want for the code because they didn't ask you to deliver it. However, if the FAR clause is in your contract that talks about delayed delivery or deferred ordering, deferred delivery of the code, if that clause is in your contract, they can come back later and ask for you to deliver the code, even though they didn't ask you to deliver it ahead of time. And depending on how the contract is structured, that could also be the same. It could also apply to embedded code into hardware. So just be aware of that as well. So in theory, if the government wanted to deliver some vehicle and have certain, either an API connecting something inside the vehicle to something else inside the vehicle, or they needed some sort of code to make the radar function inside the hardware that you were bringing to them. If there's a delayed ordering clause in there and they realize they didn't order the software, they could potentially try to ask for it back. There might be arguments depending exactly on how the contract's worded to push back on that, but there's a potential risk there. Another question, if I submit works on the project which I do not believe are patentable, can the prime or the government still attempt to claim them as patentable? Would I be able to lay claim to being named as the inventor or anything else? So yes, if the prime contractor attempts to patent something, you're going to get a letter, because I've never seen the government not ask for waivers and releases to be signed if they are trying to elect to take the patent. So in the case where someone is patenting something, if it's the government, they'll send you a letter. They'll send the prime a letter, say, I need waivers from everyone who worked on this, including the individuals, to assign all of their rights over to me, the government. The prime might try to send it to you and say, I want you to assign it to me so I can assign it to the government. To the extent you can, you might want to push back on that and say, look, I'm going to give it to the government. I'm not necessarily going to give it directly to you, whether that's rights or title or ownership or any claim to rights or title. And frankly, if you're a company and you have employees working on things and you don't have in your agreement with them, any sort of, either it's an employment contract if you have that, or in your handbook that they signed, that they've already waived and released any and all claims to any IP created or which will be created or anything like that, you want that handed over to you as the employer as well. Because if an employee creates something and you haven't had them, the work made for hire thing, people misunderstand sometimes. It's not necessarily automatic. If they've invented something that's potentially patentable, and if you don't get them to waive rights in it, and you can do a present waiver of future rights, but it can't say you will waive your rights. It has to say you hereby waive your rights, as in today, to anything now or later developed under your employment with me, something to that effect. As opposed to anything you create while employed with me, you will waive your rights. That's something that they're going to do in the future. And if you never actually go to them and have them waive the rights in the future when something's created, it won't be effective because you never did it. You said you will do it essentially if I ask you, and you never actually asked. Whereas if you have language that says you hereby waive your rights to things in the future, it's a present waiver of future rights. So you'd want something like that as well. When you're talking about previous work, If you have something that's going to be mixed, and actually maybe I'll get into that later when we talk about the mixture of different types of rights, because we're getting into a minute. You have technical data, you have computer software. When you're talking about when do the rights attach to something, and it's when it's developed. So you don't automatically have rights, and therefore the government doesn't automatically have a claim to rights in something that was previously developed. And there's an asterisk on that I'll get into in a second. But if you previously developed something, and that essentially means that there's something that if it's software, it can be compiled, is probably the best way to think about it. If it can run and do something, then the code has been developed at that point. If it's a prototype, it doesn't necessarily have to build something physical like this keyboard. You don't need to build a physical prototype for it to have like a high probability that it'll work as intended. It can be a computer model, it could be even an idea, but if there's a really high probability that it will work and you've drilled down far enough, that's when it's been developed, and that's whenever the various questions here of rights attaching applies. If it's just this idea that, you know, it would be great if we could take two hydrogen atoms, push them so close together they would fuse into helium and create energy, let's do that. That's not enough. It's not enough to patent that. It's not enough to get a copy. It's not enough to do anything, okay? Nothing's been developed. It's just an idea. When you get down to the point where you have this prototype of how it could potentially work, that's, you know, fusion, by the way. When you've created fusion energy, right, and you figure out how to make it work, great, good on you. But until you've gotten down to that lower level, you haven't developed anything, which essentially means that if the government's trying to take rights from you, it won't be effective because nothing's been developed for them to have rights in. You also have to look at who paid for it. So who paid for that development? Did you pay for it? Did the government pay for it? Did everybody pay for it? Can we even tell who paid for it? Which is why it's very, very, very important to take this development concept and pair it with this who paid for it concept. If you've developed something and you did it all with your own money, which can include G&A or IR&D, whatever funds, not funds where the government said, I'm hiring you to create this. You did it on your own. If you did it, and all of it, all the coding and all of the software, let's give that example, all the software was coded at your own private expense using G&A funds, not direct bill from a government contract. In that case, you would have all rights and title in that. The government would have none, okay? If you have a situation where the government paid you to write code, that's what the contract is for. Most likely, the government would have unlimited rights in that. And the general rule is that the government would have unlimited rights. That means they can do anything they want with it. They could give that code to another contractor and have them come in on the following contract and do all the work instead of you. If it's mixed funding, meaning, and mixed funding for development, remember, which is this other definition up here. If you did half the code and the government paid you to do the other half of the code, or even you did 5% and the government paid for 95, or you did 95 and the government paid for 5. But that last 5% is what took it over this line of development, then it was technically developed with government money or with mixed funding in this example. If it's developed with mixed funding, specifically under the DFARS, that creates government purpose rights. Government purpose rights is not a great place to be if you're a federal contractor, because that means for you, if your only market is the federal government, it's not that different from unlimited rights. The government can still take that item or software or whatever it is and give it to a third party for the purpose of doing something under a contract with the federal government. And if that's the entire market for the software you created, then you don't have a market anymore. Your customer owns essentially the rights to do this. They don't own the code though, or the product. They own the rights. They have a license to do anything they want for a government purpose. What that means is if they give it to a third party to perform a contract, that third party cannot go in the commercial marketplace and start using that code. That would be infringement of your common law copyright in the case of software, even if you didn't register the copyright. You might want to register it to be safe if it's some great software that has some commercial application, because then it's easier to determine that there has been a breach or infringement, and it's easier to also sue that third party who's using it in the commercial market. I get the question all the time about, that seems like a real pain. How am I going to know if people are using it? That's a really good question. And what can I do about it other than sue? Nothing. The way our systems work, lawsuits are how you redress, civil issues. And when it comes down to software, it's no different than, I don't know if you've seen some of the high-profile music cases, but it's very similar to that. They're going to look at the code and they're going to say, here's what your code says, uncompiled, or right, like look at the actual raw code. Here's what is inputted. Here's what they have. Do any of these lines of code line up together that were your proprietary code? If so, how much of it? What's the likelihood that two people could come up with something similar independent of one another? Did they have access to that uncompiled source code? All of these questions come into play when you're trying to determine whether or not there was infringement. And you're going to have expert witnesses that are going to go through the code and make those arguments. And then it's whatever a jury thinks is right, which is similar to like all music, right? You look at the cadence, it's not just good enough to say they use these 3 chords in sequence, because like a million songs do that. There's all these other components to it.
Right. I do see a question here about self-funding and SIBRs. Do you want to get into that one now, or do you want to hit that one later?
Yeah, so SIBR is a different animal. So when you're talking about SIBR stuff, they're under the current rule, which is relatively new, a few years old now. The government can pay for something, but if it was under a SIBR contract and it gets to the point where it's worth something, you actually can restrict the government's rights. So you retain ownership, which is generally always true, except in that patent context where you don't elect. In every other context, you're supposed to maintain ownership and title. But with SIBR, the government also doesn't get unlimited rights or government purpose rights. The government gets restricted rights for 20 years. After the 20 years runs, which if you're being honest, in the case of software, by that time, it's probably not even worth anything. So you're basically, for the entire value cycle of your software, you can restrict the government's rights. The government gets restricted rights, but after that 20 years, they get government purpose rights. So if you're doing some software for, say, some major component, you're building something that might last a really long time, like the fuselage or whatever for like the B-1. I mean, for God's sakes, that's what, 1950 something, and it's still. So if you're doing something like that, in theory, after those 20 years, the government would get government purpose rights. And at that point, they could have someone else manufacture that item or modify that software. But for that first 20 years, you can restrict the government's rights, so long as, this is stuff we'll get into in a second, so long as you put the appropriate clauses and legends, in particular legends, the appropriate legends on that intellectual property when you deliver it to the government in future contracts. So if you develop something that works in some SIBR context, you're going to commercialize it in the commercial marketplace and you get it copyrighted and everything else, great. When you deal with the government, if you take something that you've copyrighted and you sell it to the government, you're providing it to the government, and you have SIBR rights, you need to put the SIBR rights legend in that deliverable to protect it. Otherwise, you could also turn over to the government unlimited rights in something that you created at private expense. And that's also true in other contexts, which can go down further. I'll get into that in a minute because it's after this. Let's get through this kind of quickly. So there's different types, right? You've got technical data, computer software, databases, and computer software documentation. If you look in the FAR, there are different rules for all of this stuff. But just know, here's some of the general definitions that technical data is essentially anything that is of any sort of scientific or technical nature that's not software and not software documentation. Anything like that is general technical data. And you would have to look at the technical data clauses about what to do from there. If we're talking about computer software, that's kind of self-explanatory what computer software is. Really, with computer software, you're talking about commercial versus non-commercial. If something's commercial, it fits these definitions, and you can try to expand this a bit. I've done that oftentimes, try to say, well, something is, we're on the cusp of commerciality, or there's definitely some commercial applications here. So we need to protect this. We did it all at private expense. We developed this code at private expense at that crucial moment, and we have some commercial potential for it. So instead of providing it or selling it to the government using the non-commercial clauses, which have all these different legends, we're going to provide it with a actual license agreement, a commercial license that's been slightly modified because there's certain things like indemnification clauses the government can't agree to. When you're talking about license rights, again, government gets a license to use it. You're supposed to retain title or ownership, which means you can use it for any commercial purpose or anything you want. Another thing to note is if you've co-developed something, you need to be very careful with that. If you co-developed something with, let's say it's a sub and a prime, and you don't really talk about what happens if there's joint effort on something, and you create joint intellectual property, the default rule is that everyone gets joint ownership of it. And joint ownership means they can do anything they want with it, including give it away for free, which just eviscerates the value of that thing you just created. So what we usually recommend if there's been joint development of IP is that in addition to just saying we both own it, you need to cross-license it to each other, so that the license terms will restrict what either of you can do. And the sky's the limit on that. You could have it be specific, like, I'm going to do it in the government, you're going to do it in the private sector. I'm going to do it for these agencies, you're going to do it for those agencies. Or it can be as simple as everybody can use it for whatever they want, but you can't do something with it that would materially devalue the intellectual property, or you can't give it away for free, things like that. You want to put some box around what the other parties can do. And if you have that cross license, then even though you own it or the other guy owns it, what you can do with it is restricted insofar as if they breach, you can sue for breach. And that could be quite substantial. Now, like any other breach of contract, though, there's a limit there. If somebody has no money and they give something away for free and you sue them for the value that this thing could have had, you might be out of luck because you can't get money from a stone. Or blood from a stone, whatever that, or money, or
Either
money.
way, you can't get anything from a stone.
Right, right.
But that also goes to the question of, like, if you don't put a box over it, do they necessarily, and you co-own it, does the other party necessarily have to tell you what they're doing with it? So you would have to rely on figuring it out. So having that box and those restrictions around it probably saves everybody a big headache.
Yeah, you could even have something in there, like anytime you're going to use this for whatever purpose, you have to notify the other party of its use. Now that could be administratively burdensome, but you could have something.
It's a possibility.
Okay, now getting into the sort of types of rights. I know we've briefly kind of touched on some of this, but limited rights, if you've developed something at private expense and you're talking about, I think up here, yeah, all of this we're talking about it's not related to commercial. If you have commercial software, it's a totally different animal. So if you're dealing with, say, non-commercial software in this example, then all of this stuff would apply. If you develop non-commercial software 100% at private expense, then you are able to give the government restricted rights, is what they call it in software. For technical data, it's limited rights, but it's the same thing, where you can tell the government, hey, this is non-commercial, but I'm going to use it on this contract, and I'm going to give you a license to use it on this contract and only this contract. And once you stop paying me, your right to use whatever this thing is evaporates. You can never do it again. That's essentially what limited or restricted in the case of software. That's what this is. It's meaning that you can restrict the government. However, because you're dealing with non-commercial, all these non-commercial FAR clauses or DFARS clauses apply. And when you're dealing with that, you have to put the exact legend from that FAR clause on the deliverable. If you do not do that, it is a non-conforming clause, or legend rather. And if it's a non-conforming legend, you might have accidentally given up the limited or restricted rights and given the government unlimited rights. So be aware of that as well. That's why non-commercial is so much more dangerous than commercial. Because if you look at especially the commercial software DFARS clause, it literally says there is no clause that deals with commercial software. Go negotiate it between yourselves. It's essentially what it says. And so that gives you a lot more freedom because you're dealing with just commercial software. You don't have to worry about legends. You don't have to worry about any of that stuff. If it's non-commercial, though, you have to be very, very, very careful that you put the specific legend from the appropriate FAR or DFARS clause on the deliverable it's given to the government. And if you're giving them source code, I recommend putting the legend inside of the code itself in some sort of non-readable text inside the code so that it's clear which parts of this code are given with restricted rights versus unlimited rights versus government purpose rights, because you could have an example where you're developing software and the core component of the software was private expense, but then the government wants you to add functionality to it. If you can add that functionality in sort of a module way, that can be added or separated. Like think about, add-ons to Word or to Chrome or whatever, right? You have these plugins that can come in or come out, and they have certain functionality, but they're separate. If you can do it that way, that's what I would recommend, because then you can say, here, I'm putting a box around this core software. Yeah, I'm giving this to you with restricted rights. However, you paid for this little module that attaches to it. You have unlimited rights in that. But at the end of the day, if it's a specific module that works with, say, Microsoft Word, and the government paid for that, they don't have Word, they have the module. So if some third party wanted to create something, the government could have somebody do it, but they're not going to be able to take Word. They're going to have to write an entirely new word processing program and then have this plug into it, which is probably not feasible. So that's a good way to protect yourself. But if you have and Word's not a good example, that's commercial software, but it was non-commercial. If you can make a mistake, if you don't put the restricted rights legend on this and you give the whole thing over to the government, you give them unlimited rights. And then all that work that you did, you could just render worthless. There are provisions that allow you to go back after the fact to try to correct that problem, but it's not automatic. We already talked about that. Government purpose rights, again, is mixed funding. I've already talked about that. If you have mixed funding, then you've got issues because it's, if your customer is the government, it's almost like giving unlimited rights to them. And unlimited rights, they can do whatever they want, as we talked about. So you don't really want that. Protections. So I know there's some questions. I'll try to get into them if I can, but when you're dealing if you're a subcontractor and you have limited or restricted rights data, you want to try to bypass the prime if you can. The prime might not allow that, especially if they have future plans for something, or they want to continue working with you. But you don't necessarily have to have the legends on everything if you're a sub giving to a prime. But if the prime doesn't put the legend on there because you didn't do it, and then they didn't do it, and they give it to the government, the prime might have been promised, in that case, would have promised the government unlimited rights in that thing that they've just given over to them. However, if you didn't give the prime contractor sufficient rights to do that, then the prime doesn't have the legal authority to give those rights up to the government. When the government finds that out, if they find it out, because say the sub sues the government or something, the government's going to come back to the prime and say, you breached your contract because we agreed I would have unlimited rights. Or more specifically, you didn't tell me that I was going to only have restricted rights. And now that I'm sitting here looking at restricted rights, you breached the contract. This is going to cost me however much. And I need to resolicit, or I need to buy a license from your subcontractor. It's going to cost me $10 million or 20 or 100 million or whatever it is. I'm going to charge you, prime contractor. But that's still a headache. So ideally, as a sub, you'd want to make sure you're discussing with the prime, you're clear on what you're giving them, they're clear on what they're giving the government, because not only can this cause a financial headache and a lawsuit that you might win at the end of the day, but the government customer that you might have been creating a somewhat relationship with, even though you're a subcontractor, might be really angry. They might think you played them or something like that, and they could be really upset.
Not a great way to get follow-on work.
Right, exactly.
We're trying not to make enemies here.
And that's why getting out in front of it, right? If everyone's aware of what you're doing, then great. Or if it's commercial software, give the prime the license agreement. Say, here's the license agreement, or I'll license this directly to the government. I'm not licensing it to you. Some of the bigger primes won't let you do that. They'll really push back pretty hard on that, I think, in most cases. But even then, there are things that you could do. You just negotiate it down. But again, if it's commercial. If it's non-commercial, you got to be much more careful with what you're doing. The exact phrases, license, and legends from the FAR for everything that you're doing. And you have to have the right one, right? If it's a DoD contract and you're giving something to the government, you want the DFARS legend, not the FAR legend. Otherwise, It's not conforming. Again, there are ways you can fix it, but it can be a headache. And if it's 2 years into the 5-year contract and you're like, oh my God, I messed up, the government has no obligation to let you fix it. They are allowed to, but they're not obligated to.
Right.
So be aware of that as well.
Yeah. And I think a lot of this comes down to the fact that we do want to keep as much as we can, right? But when you talk about negotiation, there's also a piece to be said for, like, hey, you might have to give a little if you want to get certain work done. And so it's kind of what you're comfortable with and how much, it's worth in the grand scheme of things and what you're going to use it for.
Yeah, unfortunately, I've had a number of people too that do work for the government, and they feel like the government's come back to them for 20 years.
Right.
And then all of a sudden somebody comes in new and wakes up and it's like, wait a minute, we have unlimited rights in this. Or we paid 20 years ago, we paid to develop this. Why are we going back to the same person? Why don't we put it out for bid and we take all the source code and we throw it up on the bidders library, let everybody look at it, let everybody bid on it, go to town. And the clients, are all upset about that. Like, they're taking our software. No, not really. If you never protected it ever,
right,
then you gave them unlimited rights in it.
So it's important to know what you're doing and where you're going.
Right. And different contracting officers may be more or less aggressive.
Right.
Again, just like push back on work made for hire stuff, because if the prime contractor is saying, look, you're doing this for me, I own everything, I own every derivative work that comes out of anything, you want to push back on that. If you have pre-existing IP, you want to carve that out. And then if you have pre-existing IP you're adding on to, what's going to happen with those derivative works? You might say, well, we're adding this new thing to it, they're paying me for it, I'm fine with that. I'll just use it later. If I want to use it, I can use it, but I'm going to transfer the ownership to them. No, that's not how that works. If you transfer title, you cannot use it anymore without infringing on that ownership right. What you need to do in that case, if you're transferring title over this new piece, is you have to get the license back. Like we talked about with the cross licensing, same thing here. If you want to be able to use it later, but you're transferring title to someone else, you need to have a license from that new owner to use it in the future, or you're infringing on the copyright, the patent, whatever it happens to be. So make sure you get that kind of thing also if you're doing that. Again, it's only non-commercial. All these things with the specific legend and all these other issues, it's for non-commercial. If it's commercial, you can actually have a commercial license agreement. There's just certain things that have to be taken out of it, which I think I'll get to here. We already talked about SBIR, STTR. But one thing we didn't talk about is, and I've had this come up, if you're doing something under the SBIR, STTR programs, and it's patentable, I had someone create a mine roller, right? And this mine roller, they patented it. That's great that you patented it, because now no one else can take that thing from you in the commercial marketplace. But there's some not great case law on SBIR protections. And this is under the old regulations. I don't think there's a case on this under the latest changes, but I don't know of any reason why it would be different. Where to assert SBIR rights, you have to protect it and not make it public. By filing a patent, you have automatically made it public.
Mm.
And so in that context, I've had the government attempt to argue, and it never went to the end of the case, they settled, but the government tried to argue that you've made something public, therefore you don't have the SBIR protections on it. We have it. You have a patent, great. So if someone tries to do it in the commercial marketplace and make a commercial mine roller, then you can sue them. But as to us, you didn't sufficiently protect it. So you might want to think about, what are the implications of this technology that I'm creating? How valuable is it? Who are my customers? Is my customer this one person, or is my customer the other person that I'm doing this with? And if it's the government, I might not want to patent it. I might want to actually attempt to do something else with it, right? I might want to just leave it alone, keep my SBIR rights, because my government customer is my main customer, and I don't want to give it away.
Right. Depends on where the risk falls too heavy.
Right.
Right.
I
Do you know that we have a quick question about the legends? Because I know we've mentioned them a couple times, so I wanted to ask real quickly. We mentioned the FAR, but where exactly do we find the legends to add?
So if you look at 52.227 or 252.227, that's where all the IP stuff is. 52.227 is the FAR. Obviously, I mean, you might know 252.227 is the DFARS. And to the extent that other agencies, I know NASA has some, DOE has some, that there might be the supplement. So whatever the precursor number is, like 352 or 852, whatever, right? Depending on the agency, but .227. If something says .227, it's a good bet that it's IP section of whatever the regulation is. So for instance, in like 252, 227, 7014 is the generic data rights clause, okay, for the DFARS. So 52, 227-13-14-15, you look in there, those are the FAR clauses that will have all of the data rights provisions, and the legends will be in those clauses.
And if I have a deliverable and I send it in, does it suffice to stick the legend like on the front and then do a little annotation within that says like, hey, refer to page 1, or do I need to put it directly next to all of the things that I'm utilizing that legend for?
So if it's, let's say you have something that's like a webinar or whatever, it's like a package of something. If you're saying here, I'm putting this legend, like this should not be separated, and then boop, you put the legend on the front of it for like technical data, that should be sufficient. To be safe, you might want to put it, if it's something that could be separated, like a package or something, or a binder. To be safe, you might want to stick it on every single page.
Okay. Just to make sure. Somebody had asked that, and I was like, that's a great question. Like, where do I have to put it?
And then with software, that's where I do recommend, if you have like a thumb drive or something you're submitting, that it's sort of on there, if you can do that, or like on a CD, which is very antiquated, but, or like a splash screen, right? If there's something where you have to click through, it pops up, you put it on there. Now, a government official who's not a contracting officer can't bind the government. So just putting something on a splash screen is not enough. You have to, first of all, in your proposal, if you look at the 7013 or the -14 clause, you'll see it'll say in your proposal, you need to designate if something is other than unlimited rights that you're proposing, if it's designated in your proposal. And there's even a chart, the DFARS is the most commonly used one. There's like a chart that says What is it? What are the rights you're asserting? And what's your basis for asserting those restrictions? You fill out that chart, you put in your proposal, and then when you actually deliver it, you put the specific legend on the deliverable inside the source code if you're doing it that way with sort of brackets. I'll put like the legend here, anything after this, here's the legend. Then you put the code, you put another legend to kind of box it.
You're literally boxing it in, you're legend boxing.
Right. That's, I mean, that might be overkill, but that's with this
Better
kind of
safe than
stuff, I try
sorry.
to be careful. Yeah.
Yeah, I mean, I think in this case, especially when you're dealing with things that you create, it's almost better to do a little bit more just to make sure that you're kind of covered.
Right.
I know we have several different questions here, which is great. We love these. If we don't get to all of the questions, I'll make sure that we kind of follow up in a personal email after that, so not to worry. Somebody asked, let's see, if the government paid for changes to an existing already developed design, how does that change the rights that are assigned to it?
So that's the kind of thing where you have to be careful. So if you did something and you didn't have a commercial license, ideally, if it's commercial software, let's say, you would have your commercial license cover what happens with what they would call derivative works. You'd want your derivative works to be covered, and ideally that you would maintain title and that the government would have whatever restricted rights in it. Try to do that. If it's non-commercial and you delivered something to them and they asked for modification and you didn't mark it or protect it in any way, you could have just given them unlimited rights in the entire thing because you didn't do it appropriately. If you're in DoD, you could argue that there was government purpose rights, which, although like we've talked about, is not ideal either. Ideally, if you did that, you might want to try to claw back and say, oh, wait, to be clear, this thing was pre-existing that we developed at private expense. And then say, we're giving you this if it's non-commercial, do the legends, you're getting restricted rights if it's software, you're getting limited rights if it's technical data in this, and then in this other piece, fine, you have unlimited rights, you paid for it.
That makes sense to me. Another, I know we kind of talked over the SBIR piece, and I just want to reiterate. It says if we invented a new device under a SBIR but don't patent it, what's to stop another contractor from producing and selling the device for government contracts? I believe there are certain things within the SBIR program that do protect you from that, correct?
Yeah, so if you created something that is, patentable, right, and it's not copyrightable, it's just patentable, then you could still, if someone were to find out about it. So first of all, you got to keep that kind of stuff close hold. Okay, if somebody finds out about something and they rush in under the current regime that changed 5 or 6 or 7 years ago, it's now first to file in the US. It used to not be like that. So in theory, if someone rushes in and files a patent before you get there, then yeah, they could potentially use something. But you got to keep that close hold. If you did this under a government contract and the government learned of it and gave it to a third party, you could sue the government. They would be responsible for that, because that would be an improper dispersal of information that was protected under SBIR. If it's software, it's less of an issue because it's more copyrightable, and copyrights don't have to be public.
There you go. Somebody said that we've been told by the government that we cannot label hardware with rights legends and can only label the paper data associated with that product. Is that true?
Not necessarily. If you're talking about if the hardware itself is something that you created, right, that could be something that would be patentable as opposed to copyrightable, which might be what they're talking about. They might be saying you can't put a technical data or restricted rights or whatever legend on that because it's not that. It's something that's patentable. Generally, if it's a physical item, it's more patentable than copyrightable. So that's probably what they're talking about. So that would be something where you'd have to elect to take the patent and all that kind of stuff.
There you go. Just a different section of that. And somebody says, I think I heard that if you develop something with G&A, that would be considered a private expense. But I always assumed that since it's part of your rates, it would still be considered a government expense. Is that true?
No,
You're baking it in.
it's what you said first. It is a private expense. So
Okay.
anything developed, it's only if the government paid to do the development is essentially like a direct bill. So because everything you do in your company and like all your overhead people are going to be billed somehow, right? Or you're losing money on them. I mean, it's not an unallowable expense, I guess is the point. It's not like alcohol or parties or advertising.
Right.
And
Right.
so anybody you have working for you, that's going to be put in your rate somewhere. And if they're not billing it to a government contract, that's private expense.
We had this one that says, can a contractor deliver a GPR non-commercial software with a copyright legend along with the appropriate GPR, which is restrictive legend? Can you just keep sticking things on there, or is there like a limit of stuff you're supposed to put on? Can you combine the two?
So I wouldn't try, because that can get confusing. They
Right.
get kind of this non-conforming. What I would say is, to the extent that something's going only to the government, use the specific legend from the FAR or the DFAR if you're talking about non-commercial data or non-commercial software. If there's another contractor involved, in fact, I just did this yesterday. If there's another contractor involved, you want the legend vis-a-vis the government. And then potentially, if there's a third party that's not like your sub or your prime that's involved, you would have some agreement with the government to have like an NDA or a license, whatever you want to call it, so that if the government shares it with a third party, that it would be clearly labeled as copyright your company. You don't need the legend vis-a-vis you don't need the legend from the FAR for a third party, but you would want to still have it labeled as being copyrighted to put the third party on notice. So that's where you can use both in a sense.
Right. And I'm actually gonna, since I know we're running right over time, I want to thank everybody for being here. I'm going to add one more question that I thought was a very interesting, quick one to end us here. And then I have just some couple quick announcements. I'll let everybody go. What are your pet peeves of the government doing or not doing remarking and legends? Is there anything that you're like, I wish we didn't have to do this, or that people keep doing that you have to fix?
I mean, the idea that like there's magic words. I mean, I hate this. There's other parts in the law that are like this, but the idea that you have to have magic words that are exactly written verbatim is the dumbest thing I've ever seen. It's just a trap, right? They're trying to trap people to give things over. That and the fact that the government has a lot of the government personnel, I think they don't fully understand the regime. And I think higher ups are saying, we're losing so much money, we need to take ownership. And they don't necessarily understand that like unlimited rights is basically for them good enough. And they keep trying to take ownership, and they don't necessarily get that. No. All you're doing, if you take ownership versus unlimited rights, you're not gaining anything, government. All you're doing is making that company not be able to ever use it again. Why do you care about that?
Right.
If you have unlimited rights, you can do anything you want with it. Let them commercialize it or
That's
sell it to other
the
companies.
meaning of unlimited.
Right.
Well, you heard it here. I want to say, Sai, thank you so much for spending the last hour with us. I know there are several questions that we didn't get to here. I'm going to compile those. I'll connect with Sai. We'll get some answers, and then I will send them out in the follow-up email along with the recording once it processes. So everybody will have that. Like I said, it'll go to the email that you registered with. And again, Sai, PilieroMazza, all the good things. It really comes down to, when you get into this space, having somebody on your side or that who really knows this world and can help you kind of walk through some of these things before you get to a place where it is a problem. As a reminder, GovMates is hosting an in-person matchmaking at AUSA if you're going to be at AUSA on October 9th. If you want that information, either you can reach out to me on LinkedIn or ati@govmates.org. That'll get it to you. And then if you find you have additional questions post-webinar that came up that we didn't answer in the email, let us know. We'll be sure to get you an answer as soon as possible. Sai, anything else before we wrap up here? Any final words?
No, thanks for coming, and I'll try to get to the other questions later.
Yeah, exactly. I love having all the questions in there. So thank you so much for giving us more than we can answer in 1 hour. Other than that, we will see you all on the next one, and have a fantastic rest of the week. Thanks, guys.